is incorporated into the second heritage impact assessment. That's absolutely clear requirement, and we know that it was understood, including by the provincial director who took the initial environmental authorization decision. There was a complaint that there was inadequate mapping. They were very specific about the inadequate mapping. They said, there are 2 maps. All those 2 maps do is they show the riverine corridor. They don't do anything else. And we'll come to what the response was to that. That's dealt with at paragraph 135.1 on page 70. One of the themes that came through on a repeated basis is, and this is referred to at the top of page 71 of the founding affidavit, the mapping of heritage resources such as was undertaken seems to have been formulated to justify a preconceived development concept. And that theme comes up regularly throughout the letter, that this was a case of taking the developer's model and formulating your reasons in a way that was designed to achieve a particular outcome, instead of conducting an independent and an objective impact assessment. And I will come back to the evidence that there is in fact...
Yeah, but so my note says here that Heritage Western Cape, they asserted that the mapping diagram based significance on ecological rather than cultural values, and reduced the far wider cultural landscape of the valley to just the rivers. The applicants contested the view that the heritage impact in the heritage impact report that the river itself is the only tangible visual element which survives as a heritage resource. The additional outstanding issues that HWC raised, or the alleged non-compliance with 38.8, would that relate to intangible significance as well?
Sorry,
intangible heritage significance? The outstanding requirements of 38.8 that is alleged to have not been complied with.
On the mapping.
I'm trying to contextualize it here.
Yes.
Is the court in a position to determine what should have been done that was not done?
Indeed, lady.
Now I'm trying to focus on it, and I'm posing the question, what should have been done that was not done in terms of 38.8 related to intangible heritage?
Indeed, lady. That's the concern that they're raising, is you're just looking at these 2 riverine corridors and nothing else. In fact, there's a lot more, including in the floodplain, that you're not looking at, and you're not looking at its significance.
You're not attaching sufficient weight to it, or not acknowledging it at all.
You're not engaging in the exercise of properly assessing significance. And part of the reason, and it's a theme that runs throughout that first letter, is that you've arrived, and I'll show the evidence that there is of that, you've arrived at the exercise with a preconceived concept and a preconceived outcome that you're driving towards. And that's not what you can do. That's why I've referred to the provisions in relation to independence in the environmental impact assessment regulations. And there's compelling evidence that I'll demonstrate to your ladyship to show that the complaint that was being raised by Heritage Western Cape was absolutely legitimate. There's very clear evidence.
But at this stage, the court is still not clear what the first respondent was supposed to do that the first respondent omitted to do. They filed a supplementary, supplement to the heritage impact report. It was regarded as insufficient by the applicant. The applicant's not happy with that supplementary report.
I've got detailed argument I'm going to present in relation to relation to the supplement,
but
and to show that it was indeed deficient, and that is certainly the applicant's case.
But did HWC contextualize it? I'm still at that point, because I need to know what more was first respondent supposed to do, which they neglected or omitted or failed to do, other than just a bold statement saying non-compliance with 38.8. It needs to be contextualized. What are the applicants saying? This project clearly points to the fact that 8 were not complied with, and we identified as follows: A, B, C, D, E. Because the court's impression is an overview of the heritage impact assessment shows that both tangible and intangible heritage resources were considered. And the impression that the court gets is that the applicant is not happy with the conclusions arrived at or the weight attached to certain aspects in the assessment. Is the court's conclusion correct?
No, lady, what I will identify is specific respects in which those requirements were comprehensible,
Yeah.
and those compliance were not compliant.
In other words, the applicant is saying, had you complied, you would have concluded that a development of this scale would not have been appropriate. Is that?
No,
is that,
lady, no.
But how can
no,
you say no?
because-
Isn't that what the applicant is
Because
saying all along?
it's a review and not an appeal. We can't.
Yes,
we can't.
but we are dealing with the apprehension of irreparable harm. So when I read the papers, I thought, this court must stay out of the review process. But ultimately, this court is forced to familiarize itself with all the facts that's going to be raised at the review.
Indeed, lady.
The court had no
Indeed.
option.
How else
So
do we assess
there will
prima
be this
facie
little
right?
bit of overlap between what this court should consider and what not. But the question of the apprehension of irreparable harm would really encompass such a broad spectrum in the arguments of the parties, because we're dealing with tangible and intangible heritage issues, resource value, and the weight attached to it. Which brings me back to my point. Is the applicant saying that supplementary... Oh, I'm talking too much. My throat is dry now. The supplementary heritage impact assessment submitted by the applicant, they did not compile a new report, they just supplemented. It appears as if the applicant is not happy with that either. They should not just have supplemented. They should have delved a bit deeper and maybe should have been more thorough and provided, is it a 12-page report, 11-page report? The supplementary?
I'll identify the respects in which they didn't comply, but the consultation requirement wasn't complied with,
Yeah.
the mapping requirement wasn't complied with, they didn't deal with the requirement, the assessment components of the requirement. I will run
Yeah,
through the
because the applicant
supplementary
says
report.
the assessment of significance was inadequate. Are we not back to the weight attached to an assessment or to an evaluation? Can one say, we can say that significance was assessed, but insufficient weight was attached to significance. I'm just trying to establish whether that is what the court is dealing with on the applicant's version.
So what Heritage Western Cape were entitled to say is, we've got the expertise here. We are telling you that you are not properly taking into account the starting point. The starting point is that for a particular community, this is sacred land. The entire site is sacred land, not just the rivers. They say, take that as your starting point, and then accept that that's a heritage resource and do your assessment of, first of all, significance, and second of all, impact. What they were saying is you don't get out of the starting blocks because you don't acknowledge at the start the existence of it being a sacred site for a particular community to which they have a deeply attached spiritual link as your starting point. And part of the reason that they give is the problem is they say you post-rationalize a preconceived development. And if we look at the supplement, I'll demonstrate to your ladyship exactly why that is demonstrably the case.
But the applicant is saying that the heritage resources will be adversely affected by the development. And my note here says, no proper consideration was given to lower bulk alternatives such as the mixed-use affordable alternative and the reduced floor space alternative, as
Indeed,
these were
lady.
not considered to be economically viable. So,
And
yes,
the instruction was clear. You haven't properly considered alternatives. And they don't. I will demonstrate to your ladyship that they don't properly consider alternatives.
so insufficient weight was attached.
No, my lady. There are some that well, if one looks at it, if one looks at the preface to the 2019 Impact Assessment Report, they say right at the beginning that you have got only one choice here. And that is what they were complaining about when they say you haven't properly considered alternatives. And they're correct. And I will take your ladyship to the place that shows that.
They failed to consider alternatives other than the riverine corridor alternative and the island concept
Indeed.
alternative.
Indeed, my lady. Indeed. And I can demonstrate,
Right.
the evidence to show that that is in
Yeah,
fact the case.
you may
that
proceed.
that the complaint was justified. So
So I'm busy here on page 26 and I'm looking at paragraph 59. I'm not sure where you are.
yes, I was I was at paragraph 58.
58.
I think we
Yes.
probably sufficiently canvassed what the
Yes.
range of requirements were, and I think it would be helpful if we then see at paragraph 63, we deal with, in order to assess whether the requirements of Heritage Western Cape were fulfilled in the impact assessment, the primary documents to consider are, firstly, the supplement, and secondly, the First Nations or UFMOS report. Before going there, in relation to the post-rationalization complaint, this is paragraph 64, it is worth looking at what the evidence is on the papers in relation to the consultant's mindset. In this regard, we refer to the preface to Hart and Townsend's Heritage Impact Assessment dated 2 July 2019 that Heritage Western Cape were responding to. The preface begins at volume 6, page 2420, and we refer to the second page on page 2421, where they describe their professional role as follows. Our professional role is to undertake an investigation that enables A, the articulation of the heritage-related significances associated with the site and its environs, and B, the identification of heritage, both tangible heritage, resources, and intangible practices and beliefs that are associated with the site and its environs. And C, and this is the important part, that also enables us to advise and assist the owners to propose development that responds to and respects the articulated significances, mitigates recognized potential damage to the heritage, both tangible and intangible, and ideally that enables the recovery and even enhancement of heritage resources. They then go on to say at the bottom of the page, still in the preface, and here I come to the part where I talk about a lack of options. We note that, and please bear in mind, lady, that we're talking here the preface, so before they've even got anywhere into the assessment at all. We note that most of the commentators, First Peoples Group accepted, seem implicitly at least to accept that some form of development should well proceed, but most also argue that the current proposal is simply too great. We think that this, from a heritage management perspective, is contradictory. And we think this because any development of the subject property, even single-story row houses like those in nearby observatory, would transform the site and the floodplain, affecting the wider environs in the same way, from a heritage management perspective. But importantly, a lesser development would not generate adequate funds for the great public good that we argue for, the restoration of the Liesbeek Riverine corridor. In other words, we think the choice is stark but clear. Accept the current proposed riverine corridor alternative with what we think are very considerable public benefits, or accept that the River Club property will remain as it is. Now, lady, that is compelling evidence of post-rationalization of a preconceived development concept and the abandonment of any semblance of independence. Paragraph C of the description of their professional role is particularly
So
revealing.
it's an either-or approach. You either accept it or...
It's not even two options. It's not even binary. It's one. Your only one is you've got to accept it. The only one we can talk about here. And that's completely in conflict with what their role is as independent assessment practitioners. Bear in mind the three possible outcomes that they have to report effectively to the director on, the provincial director on. Those three possible outcomes. Those we do not find here. Let's take that one. So we say it is not the function of the environment assessment practitioner and specialists to advise and assist developers to propose a development that mitigates damage to heritage. It is their function objectively, fairly, and independently to assess all heritage impacts of all alternatives, including the tread lightly development option, yes, the no-go option, and then glaringly, obviously, the option of declaring the entire area as a protected heritage site under the NHRA and rehabilitating it accordingly. This was not an as-is option. The state has the power in terms of Section 46 to expropriate on the advice of SARA. So they say you didn't consider alternatives. Here's the evidence. They don't ever address that. They just say you're wrong.
Is that ultimately what the applicant prefers? Expropriation of the property. Expropriation and preservation.
That would probably be the logic of what they say about preserving it as a heritage site. But the important point for present purposes is that that option wasn't even discussed. It didn't come onto the table. For a heritage impact assessment practitioner, it's fundamental. It must have been the most obvious alternative for him to discuss, and it just never features. We say in paragraph 67, instead, with reference to the paragraph at the bottom of the page, they made their preconceived mindset abundantly clear. Accept the developer's proposal with its bulk, or accept that the site remains as is. Framed this way, it is not even a binary choice. The HIE was approached on the basis that the only viable alternative was the developer's proposal. We will come to how the consultants responded to Heritage Western Cape's requirements in terms of 38.3 about this issue of post-rationalisation of a preconceived development. But this was a major and serious flaw in the heritage impact assessment that had been exposed by Heritage Western Cape. That triggered an obligation, we say, upon the fourth and fifth respondents in terms of the proviso to Section 38.8 to ensure that the flaw was properly addressed. Again, we'll come to whether or not they did so. So then let's have a look, milady, at the supplement to the heritage impact assessment, because that's where they say we did what we were required, what you required us to do. That is Annex LL15 is the supplement. At page 225, we can just look at page 226. There you see it's the contents page in respect to the supplement. It's in volume 1, milady.
Yeah, 226.
226.
Yes, I have it here. Thank you. Yes.
If we compare this with the list of minimum information requirements in section 38.3H-G, we see that there are already worrying signs. There is a promise of identification and mapping. There is a promise of assessment of significance.
Sorry, I'm not with you. You are on page?
Paragraph 69 on page 30 of my notes.
Oh, yes.
And page 226 of the record. We say there are already worrying signs. There is a promise of identification and mapping, paragraph A of 38.3. There is a promise of assessment, paragraph B. There is a promise of consultation, paragraph E. But we see a void when it comes to assessment of impact, paragraph C, and when it comes to evaluation of impact against sustainable socioeconomic benefits, paragraph D, and when it comes to alternatives to avoid impact on heritage, the one we've been discussing. The contents page includes two anomalous and similarly worrying topics. The insertion of a revised development proposal at the point where a logical sequence would anticipate impact assessments, and the inclusion in item 8 of a promised attack on the rationality of the document that sets out the section 38.3 requirements that they are required to comply with. If we then move on to the introduction, that's on page 228, things do not get better. The consultants say the following. While the interim comment contains a great number of statements and arguments, with one apparently central and reiterated argument, rationalizing the comment as interim, it seems to us that the matter is rather simpler. Indeed, it seems to us that there are just two issues which could reasonably be cited as reasons for the HIA to be deemed to be inadequate or incomplete. These are, first, an incomplete engagement with and representation of First Nations interests and views, and second, the contradictions and inconsistencies of the land use planning development frameworks and policies for the wider environs. So they say, we don't care what you say to us, Heritage Western Cape. The only two that we're going to take seriously. Boom, we decide. Quite apart from the breathtaking arrogance of this comment, it again evidences a deeply problematic mindset. The consultants clearly regard themselves, not Heritage Western Cape, as the appointed persons to dictate what statutory compliance requires. And while Heritage Western Cape carefully articulated its requirements with reference to all 7 of the paragraphs, they made clear they only take 2 of them seriously. What is particularly worrying again is about this again prefatory comment is that Heritage Western Cape had accurately pointed out a serious mindset problem in relation to post-rationalisation and by extension independence, and required that this be addressed. As pointed out above, the evidence of that mindset was patently clear. In the July 2019 HI, what one would have expected in the introduction was an acknowledgement of this error, perhaps an apology, and a clear indication of how the problem was now going to be addressed afresh with an independent and objective mindset. Yet we see nothing of this. We can then move on to section 2 of the supplement. That's at page 228. Engagement with First Nations groupings. The question whether this complied with Heritage Western Cape's and the statute's requirement must in the main be assessed with reference to the First Nations report of Mr. Arendse. However, what is worrying from an independence point of view is that there is no attempt independently and critically to evaluate the soundness of Mr. Arendse's consultation process. It is unquestionably taken on board, lock, stock, and barrel, not what an independent assessment practitioner does. And they can go and say, well, it's apparent that there are some First Nations groupings who do not share this view. The First Nations collective is authoritative. Arendse's report is persuasive in its method, its argument, and its conclusions, and we hope and trust that Arendse's report and the incorporation of its conclusions here in the supplement and in the revised development proposal will satisfy Heritage Western Cape, at least insofar as there has been meaningful engagement, and so on. In particular, there is no attempt to seriously consider whether it is a problem that the First Nations groupings do not share the collective and Mr. Arendse's views about the development. Also of significance is the fact that there is no suggestion or claim that Mr. Arendse was appointed in his capacity as a specialist consultant. And one can understand that because they said there were only 2 issues that were worthy of taking into account anyway. And we say, although the 4th and 5th respondents belatedly in their heads of argument rely on such an appointment being a recommendation rather than a requirement, this is the specialist consultant component, we contend that properly construed, it was a requirement that had to be complied with. And we will show, in fact, that 4th respondent agreed with that requirement about the specialist consultant. Then with reference to section 3 of the supplement, commencing at 233, we have clear evidence that the consultants have failed to take on board the complaint in relation to post-rationalisation. In relation to the planning instruments, they present one-sided arguments as to why planning instruments that do not support the developer's proposal should be disregarded and planning instruments that do support the developer's proposal should be applied. With reference to section 4, identification and mapping, the focus is on addressing the mapping shortfall. Heritage Western Cape had criticised the mapping on the basis that section 10.8 of the main heritage impact assessment showed 2 diagrams of riverine photography, and we've discussed those. We've got the reference for those. One sees simply pictures of the 2 riverine corridors and nothing more by way of mapping of the heritage resources. To address this problem, the consultants included in the supplement at pages 236 to 238 3 diagrams: a city council grading map, a diagram by Atwell and Jacobs, and a diagram by somebody by the name of Cindy Postlethwaite. These do not address the mapping shortfall for the following reasons. First, they are not dedicated to the River Club site. Second, to the extent that they cover the River Club site with an oval denoting the site, none seem to reflect any heritage resources whatsoever. And thirdly, the consultants in each case explain why the diagrams are not helpful and were omitted from the 2nd of July 2019 report. So they themselves are saying they're not complying with it. And it was simple. Draw your own map. Don't put in 3 maps from somebody else and show that they don't show what you meant to show. Draw your own map and show it. It's never done. And each one of these problems on its own is a reviewable problem because of the compulsory nature of the obligation in terms of 38.3. With reference to section 5 of the supplement dealing with assessment of significances, instead of taking on board the statutory requirements of Heritage Western Cape, they take on Heritage Western Cape. They use the words argue or argument 11 times in 5 pages. They simply reiterate their arguments as set out in the 2 July assessment, and they do so in language that again reflects arrogance and disdain for Heritage Western Cape. These arguments are epitomized by the following statements by the consultants. It seems that Heritage Western Cape has not recognized, or they disagree with, the essential underpinning logic or argument of the HIA regarding or assigning relatively low significances and or value of the lower reaches of the Lesberg floodplain and the two river courses, stormwater ditch and the canalized river, as place and or tangible heritage resources, despite the high historical significance of the immediate and wider environs. In this last respect, it seems that HWC has an incomplete grasp of the relationship between significance and authenticity. We submit that the difficulty with this section of the supplement is firstly, reliance on the 2019 assessment is misplaced because it is demonstrable that there was a post-rationalization of a preconceived development. Secondly, central to addressing that problem would have been, at a minimum, reassessment afresh of the significance of the heritage resources and reassessment afresh of the impact of the development on those resources based on an objective and independent approach. Instead, the consultants doubled down and stubbornly refused to do so. The assessment of the floodplain and the two river courses as having low significance is out of kilter with the respondents' general acceptance in their answering affidavits and heads of argument of the high significance of the site, as explained in the affidavit of Mr. Jenkins, which is generally not disputed. A revealing example of their post-rationalization of a preconceived development in the supplement is the analysis of the significance of the floodplain at volume 1, page 241, in relation to the variation over time of the course of the rivers. For the consultants, this means recognizing that the canalized path of the river is the sole legitimate feature. But if one thinks about it logically, if the consultants acknowledge that rivers were important features for First Nations people, the fact that rivers have crossed different paths on that floodplain at different points in time suggests that the whole of the floodplain is important. Instead, they used it as a basis for discounting the floodplain and supporting the canal route as the only significant heritage resource. Section 6 deals with the revised development proposal. That starts at page 244. Once again, it evidences strongly the post-rationalization of a preconceived development. The consultants discard any semblance of independent objective assessment and go out to bat strongly for the latest version of the development. Most unfortunately, at the top of page 250, instead of addressing the problem of post-rationalization, the consultants repeat the point that they made in the preface to the July 2019 Heritage Impact Assessment about the illogicality of objections to the height and scale of the development. The lack of logic lies at the door of the consultants. The height of the development is massive, with a number of 10-story buildings coming on top of the raising of the site to deal with floods, including at the sacred confluence of the rivers. And if your ladyship has a look at page 2072, one can see there that the stories of the buildings are set out in the diagram on page 2072. The two developments right up on the sacred confluence of the rivers are 10-story behemoths. In the section currently being developed, the Amazon section, there's provision for 10-story building, for an 8-story building. So for the heritage impact assessment to say 1-story versus 10-story, there's no difference. You're changing it from a golf course. It's illogical. With respect, that reflects a serious defect in their thinking. If one is thinking about it from the perspective of how does this impact on a person who wants to evoke the original natural state of the area for a First Nation person, if you've got a few environmentally appropriate low-rise developments contrasted with 10-story buildings all over the place in a very, very dense development, it's clear they have a very, very different impact. They won't accept that because they've got a preconceived idea of what must come through them. What should have come in this section of the supplement was a fresh, independent, objective assessment of the impacts on heritage resources of the high-rise, high-volume development in its new form. Instead, we are presented in Section 6 with what amount to the planning equivalent of heads of argument in favour of the development. Section 7, dealing with alternatives, from page 250, suffers from the same post-rationalising problem as the rest of the supplement and predecessor. It says again in more expanded form that the proposed development is the only realistic outcome. pays lip service to the no-go option, which it dismisses in a single sense, and it doesn't take into account the option which I've explained already, and I won't go back there again. Once again, the consultants can't help themselves from having another go at Heritage Western Cape. They assert that Heritage Western Cape's opinion, and this is in paragraph 88, regarding alternatives and mitigations, quotes, are not sustained by rational argument, and that in the 16 years that Heritage Western Cape has been operating, it has seldom required that alternatives be assessed. The stance in these last two paragraphs of Section 7 is inimical to the peremptory requirement regarding consideration of alternatives in Section 38(3)(f).